Hey, it's 10:30. Looks like everyone is here. I will call the meeting to order. First item on the agenda is approval of the December 18th, 2024 meeting minutes. Anyone have any questions? Is there a motion to approve the minutes?
So moved.
I'll second.
Okay, move and second. Any questions? Any further discussion? Hearing none. All in favor, say aye.
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 Opposed, same sign. Motion carried. Next item on the agenda, discussion of legislation, advisory opinions, lobbying by public officials, enforcement action, and all those items. Rebecca, take it away.
All right, good morning, commissioners. I hope that you are all doing well as we start the second week of legislative session. We have been monitoring, we've already testified on some bills. The pre-filed bills have already been through committee. And we'll give you an update on all of those and then get some direction from you as well on a few. So I will jump into these. I'll probably ask Logan to step in at some point or jump in. Let's start with the commission's two pre-filed bills that relate to advisory opinions. The first one was advisory opinions, and the second one was lobbying by public officials. So House Bill 1046, this was the commission's bill related to advisory opinion requests. It would allow the commission to initiate an advisory opinion upon a majority vote of the entire commission. It also puts some internal practices and procedures that the commission already utilizes into statute, and that's really just a clarifying to make sure that everybody's aware that that is the process the commission is going to follow. A hearing was held on this bill. It was the House Judiciary Committee's very first bill on Tuesday morning. At the hearing, committee members did express some concern, disfavor with the fact that this bill was introduced, that it was pre-filed by the Ethics Commission and not introduced by the legislator. There was also some concern expressed that the commission would then have more authority in this area to initiate opinions on its own. The committee did go back and forth with a discussion about whether instead of a majority of the commissioners, if there was a unanimous vote of all 5 commissioners, that was disfavored. And so there was an amendment introduced to change it to 4 out of 5 commissioners. And later, there was a do pass recommendation on the bill that failed by a vote of 2 to 12. And then a do not pass recommendation was approved 13 to 1. So this bill will come out of that committee with a do not pass recommendation. However, this bill has not yet gone to the floor. I do think that this is something that the commission, one of the sticking points seemed to be that it was not introduced by a legislator. So I think that there is an opportunity still, if the commission would like us to pursue that option, to see if we can communicate with a legislator to introduce this again, perhaps included with a different bill on its own, etc. But that it can come up that way. That is an option that the commission has, and we can certainly do that upon direction of the commission. Senate Bill 2052. This was the bill the commission pre-filed, and this did not change the law. There was no change of law on this bill. It was clarifying a caption of the applicability of North Dakota Century Code 546613, and it simply added the word elected to the caption. This bill is really a clarifying bill. on the restriction on lobbying while in office and after a term of service for elected public officials. This is one of those areas the commission does get frequent questions on, and so we wanted to make sure that this was clear. The Senate Judiciary Committee held a hearing on this bill also on January 8th. We had a little Home Alone movement or moment running across the Capitol to get from one hearing to the other. We had to kind of hurry to do that because they were right back to back. The committee, there was an opposition testimony about this bill. The opposition testimony contended that the statute and the constitutional provision were unconstitutional in the sense that they violated the federal constitution. However, it's based upon an Eighth Circuit case that came out of Missouri, based upon a constitutional amendment in the Missouri Constitution that is similar, but definitely not identical to the North Dakota lobbying moratorium. I explained those differences to the committee at the hearing. The opposition, there was testimony. That individual did present the testimony, but eventually the committee unanimously approved a do pass recommendation on the bill. This bill has not yet come to the Senate floor. We've attached a copy of engrossed bill, House Bill 1046. We didn't attach Senate Bill 2052 because it was only changing one word. But I guess I would like to know if the commission would like staff to take that House Bill 1046 as it is drafted and see if there would be a legislator or a group of legislators who would reintroduce House Bill 1046 as a legislator introduced bill instead of an ethics commission introduced bill. So I'm looking for direction from the commission on that.
Yes, if it makes getting it before the House or Senate faster or without controversy, I think we should.
Okay, I'll entertain a motion to authorize commission staff to work with a legislature or group of legislators to reintroduce House Bill 1046 as a legislator-introduced bill.
One question, Rebecca, would you introduce it in the House or the Senate? Because if you introduced it in the Senate and it passed, it might have some momentum going back to the House.
Murray, I think that would depend on what legislator we tap to do that. But I think that there are a few that we have in mind that may be the direction that it goes. If the commission would like us to start there, I think we could start with approaching legislators in the Senate already. If that would be the direction.
Would there be any problem if you're able to approach both? If you have a willing House member that's willing to go, supports it, or a willing Senate member that supports it and willing to go forward, you could do either, couldn't you? Or is this because it originated in the House that we should stick with that?
Dave and Murray, I think this gets more to your question. I don't think that we have to start in either house. I think there may be an advantage to going in the Senate, but I also think that there could be an advantage to looking at what bills we've already been working on with legislators and potentially including it in there. And I think those may be introduced in the House first. So I think it's going to have to be who we can talk to, and but if we prefer the Senate, I can certainly aim to speak with senators. I don't know if I answered the question wholly.
Ward, you're muted.
That explains that. I'm going to make a motion to authorize commission staff to work with a legislator or group of legislators to reintroduce House Bill 1046 as a legislator-introduced bill.
I'll second.
Any further discussion? Okay, Alicia, call the roll, please.
Dave Anderson,
Aye.
Cynthia Lindquist,
Aye.
Gord Kozer,
Aye.
Murray Sagsby,
Aye.
John Goodman.
Aye.
Motion carried. Okay, next item, Rebecca.
All right, moving on to the enforcement action process piece of legislation. This is something that the commission has been talking about, what seems probably for 4 or 5 months, 6 months now. The commission staff have revised the proposed legislative language for the enforcement action process, and we put it into bill format. If we go back to the meeting the commission had prior to legislative session, this was one that we had not voted on. The commission has not voted on the actual language yet because we were getting feedback from legislators. So based upon that feedback received from legislators, commission staff recommends that the commission remove the language that is seeking to clarify the subpoena process for the commission. We think that removing this particular piece of this legislation will greatly assist in getting this piece of legislation over the finish line based on feedback that we've received. In the draft that the commission has today as attachment 3, that has the bill format. It's in the bill format, and it has the subpoena process that we proposed removed. So Dave, if it's okay with you, I would like for Logan to walk through this one more time with the commission, just so that we have everybody, if there's any questions, making sure everybody is on the same page. Looks like Dave's giving you the head nod.
Alicia's going to share it so we can.
I forgot I was on mute. Okay, go ahead.
You nodded your head, Dave, so we knew.
It doesn't look much different from the last time you saw it, but it does look a little different. So we'll go through it. Okay. The first thing is it's put into sections. So section 1 is the definitions in the Ethics Commission's chapter of the Century Code. And this is what we've been over before, where it removes all references to the current complaint process and changes it to the new enforcement process. So you'll see definitions for alleged violation, enforcement action, ethics violation, final commission order. Now the next page, regulated individual, relevant information, that key piece that people will now be submitting instead of a complaint, relevant information, and respondent. And we move into section 2. This just removes language when the commission meets that it is now for an enforcement action and that it will be a closed meeting. Similar to our same process now, just replacing that terminology. Moving on to section 3. This removes the summary dismissal of complaints and then states the commission will now make those rules of procedure, pleading practice and procedure for how things move throughout the process, how things are filed, how things are served, etc. That will be moved to commission rules. Moving on to section 4. Referrals. This removes the requirement that the commission refer allegations of criminal conduct to law enforcement agency. I guess that it mandates the commission do that. And then just changes again terminology to an enforcement action. Section 5, this is related to appeals from a final commission order. The current statute doesn't have a timeline in there, so adding in that timeline of 30 days, which is in the commission's rule, but also adding 2 other courts that a respondent could appeal something to the district court in Burleigh County as a catch-all, just in case it's not covered by another court. Because currently it says where the respondent resides. A respondent could be an out-of-state resident at this point and not have a court to appeal to. Or also a district court where a substantial part of the subject matter of the alleged violation occurred. So the court in closest proximity to the allegation. Making sure that's covered there. Section 6, this is the big change to the confidential information statute. So again, changing terminology so it reflects the new enforcement action process, but also allowing both the individual who submits information and the respondent to publicly talk about what is occurring. Because currently the respondent essentially is gagged by the statute, so making sure that they're able to talk about it and defend themselves. This is aimed at eliminating potential weaponization of the commission's process. And then, if you'll scroll down, Alicia, the very end of section 6 there, subsection 5, that allows the commission to disclose information to the entity with appropriate enforcement authority. So there it's permissible, the commission's not required to, but can, if it deems necessary, refer things to the appropriate enforcement authority, whether that's a criminal or civil authority. And then section 7 repeals some current subsections that are related to the current complaint process, one of them being informal resolution, the procedure for how a respondent's informed, which will now be in the commission rule, and then the ethics commission determinations, that will also be in the commission rule, just the timeline for laying that out and how the commission meets. We discussed moving that to the rule instead, so that is the legislation.
So with that explanation, thank you, Logan. Any questions from the commission on this?
This is Murray. I have a question. Is there any potential conflict between Section 4 and House Bill 1141 if this is introduced?
Potentially, Murray, I think 1141 would require the commission to refer certain conduct related to lobbying to a law enforcement agency. I think that would be more specific in specific instances. If that legislation passes in its current form, the commission would still be required, which it's currently required to do, required to refer those allegations to law enforcement. But that would be in those specific allegations or those specific instances where that's alleged. As a more general concept, the commission wouldn't be required to do that anymore for other allegations with this piece of legislation. So yes and no, we will monitor it as it moves along in the process. I think right now they're okay, but again, the commission has expressed it wants to get away from the criminal referral realm and focus on civil enforcement. So that's what this proposed bill seeks to do.
And it seeks the ability so that our efforts aren't weaponized by complainants.
Correct. That is one of the goals that it seeks to.
Any other questions?
So Dave, based on that, if the commission could authorize us to work with a legislator or a group of legislators to introduce this revised enforcement action, it obviously would look likely a little bit different once it's introduced, but that we work with legislators to introduce this and then support that piece of legislation once it's introduced. That would be helpful to our work.
Okay, I'll entertain a motion.
I'll so move in the language that Rebecca suggested.
Do I have a second?
This is Murray, second.
Any further discussion? Hearing none, Alicia, call the roll.
Dave Anderson,
Aye.
Ron Goodman,
Aye.
Murray Segsving,
Aye.
Lindquist,
Aye.
Ward Kozer.
Aye.
Motion carried. Thank you for that. Next item.
Yep. Next, moving on to the next piece of legislation. This is the financial disclosure statement / statement of interest work that we have been doing. This has been in conjunction and a team effort with the Secretary of State's office. This is really just to update the commission. The commission has already authorized us to work with the Secretary of State's office and legislators to have a piece of legislation introduced. So we don't need authorization, just wanted to update the commission that we have gone back and forth, and I'd say that we are very, very close as of today, nearly final, but not quite final, on language, and that we expect something to come of that later this week. We will keep the commission apprised of what happens with that one, but we are nearly final in that language. So any questions on that? Hearing none, I will move on to the prohibited actions provision. This was first talked about in, I think we talked about it at the October meeting, and then we also last talked about it on at the November 20th meeting. And we discussed this proposed language as a piece of legislation related to prohibited actions, meaning that a person cannot be threatened or that there cannot be a retaliatory, disciplinary, or other adverse action against a person who acts in good faith and provides relevant information to the commission. This, based upon discussions with the commission and the direction of the commission, this bill was not pre-filed. It was not introduced by the commission. Since the last meeting, Logan and I have talked with a few other ethics commissions across the country. And then we've also conducted additional research. We've also touched with the Attorney General's office. And at this point, commission staff, we believe, based upon advice from our general counsel, that the goal sought in this particular prohibited action section, that we can do this through commission rule preferably after legislative session, so that way we don't have too much going on right now. And so we recommend that the commission revisit this issue in the form of a rule rather than a piece of legislation later this year. This would likely be in conjunction with any amendments and revisiting a holistic review of the commission's rules in general. And so we'd like to take that issue up at that point. Any questions, considerations on that piece of legislation? Hearing none, let's move on to House Bill 1141. There also has been a few other ones that we have, that we are keeping track of, that we don't need to discuss at this point because they're so new. But the hearing on House Bill 1141 is quickly approaching. It is this coming Thursday. This has been attached as attachment 5, engrossed House Bill 1141. So House Bill 1141, it was filed late last week, and it does directly impact the duties of the Ethics Commission. We've provided just a short summary for the commission. You can read it in attachment 5. It adds a section to chapter 16.11002 that precludes state agencies and political subdivisions from using public funds to be a member of or contribute to or endorse a private organization that has endorsed a candidate or publicly supported or opposed a ballot measure. So you can find that in subsection 2 of section 1 on page 1. You can find that language right there. It then goes on in section 4 to say that an individual who's alleging a violation under this section may file a complaint with the Ethics Commission as authorized in 546605. That is really just the process for the complaint rules, or the complaint process. And that the processes outlined in chapter 5466 then apply. So this requires, if you go to section 5, which was the section Murray previously referred to, Commissioner Sagsveen referred to, if the Ethics Commission believes the complaint contains allegations of criminal conduct, the commission shall refer the matter to a state's attorney of the county in which the alleged conduct occurred. In section 6, it then outlines a procedure basically that would require, or there's shall language, that the state's attorney shall prosecute the violation. However, if the state's attorney refuses to prosecute, the commission shall then refer the matter to the attorney general for prosecution if authorized by a majority vote of the commissioners. So basically a majority vote of the commissioners. Sorry, I repeated myself. I did not mean to. If the commission then authorizes the attorney general to prosecute the action, the attorney general files the action in the Supreme Court, and it exercises original jurisdiction and holds the trial there. This is not a process that is currently in place. We have reached out to the Attorney General's office. We reached out to Mary Kay Kelsch in the Attorney General's office in hopes that we can perhaps provide some clarity to the committee on what this process would look like. As Murray already alluded to, in the commission's enforcement action legislation, we're hoping to get away from this required criminal referral. But I imagine that section 6 of this, with the interplay of the Attorney General and state's attorneys prosecuting and the Supreme Court, I suspect that there will be a lot of information and discussion on that point. And the commission will certainly provide information about its processes to this discussion. The hearing on this bill is, I believe it's scheduled for Thursday. And so at this point, I didn't include it as a motion because I want to get some discussion from the commission, but I think it would be, I would advise the commission to stay neutral on this bill, to maintain a neutral stance, and to simply provide the committee with information about the commission's process and the new enforcement action that the commission is moving toward, and how that likely does not work well. I mean, it can potentially work with Section 5, but likely does not work well with Section 6. Did I accurately say that, 5 or 6?
5 is really taking what's currently in our chapter of the Century Code and putting it in this section as well. So that instance it's duplicative, but also the commission is seeking to amend that anyway and change it. So we'll work with the committee and the sponsors to address our concerns in that arena.
As well as the Attorney General's office.
Yes.
Any questions, suggestions, thoughts on that piece of legislation? Or direction for us as we navigate this one?
So basically, you're going to work with the committee, and you've alerted the Attorney General's office to the language. You're going to work with the groups to us. I mean, I agree we should stay neutral on this, but you'll try to help them out where things get confusing.
That's correct, Dave.
I think that's a good plan.
I think having them understand the commission's process and how the commission does not authorize individuals to prosecute actions. That is left to the discretion of prosecutors, not to the commission. Those sorts of informative things to understand would be very helpful for the discussion.
I think you can just go ahead with that. One request I have, and I don't know if you can do it, but can you turn the volume up for you folks? For Rebecca, Alicia, and Logan?
Can't. Maybe try. We'll try, Ron. Give us just a second.
Okay. I know I'm an old man and everyone else is young here, but I have trouble hearing it.
This is Murray. I have a couple of comments. I've argued a case, an original jurisdiction case before the Supreme Court. They don't like those, and they take them very seldom. To have something like this begin in the Supreme Court, I imagine I wouldn't be surprised if the Supreme Court testifies about that. And on Section 2, I imagine that there will be many private organizations testifying on this. So it will be an interesting hearing.
Murray, I fully expect the court will have somebody there to testify because I think the language as currently drafted will require the Supreme Court to have a trial. We all know the Supreme Court's not a trial court, so
No.
it should be very interesting.
Stay in the bleachers on this one.
Yeah, I think we all concur that we should stay neutral on this, and Rebecca, you guys should assist where possible.
Okay, we will do that. I anticipate that we'll submit written testimony that's neutral. I would, again, stay in the bleachers is probably a good recommendation from a testifying standpoint, but I do think the commission probably should submit neutral testimony, written testimony. We may want to testify. Logan is telling me we may want to testify, but we do hope to talk with the bill sponsors more this week, as well as the Attorney General's office, and maybe even touch base with the court. We have not done that yet, but we can do that to perhaps come up with a solution to the unique language that's been presented by this House bill.
I hate to be a dummy, but I'm going to be. Could you summarize what this is? I missed exactly what the substance of this bill is.
Yep, Ron, can you hear me now?
Yes.
So this is a bill that has been introduced, and it amends Section 16.1, 1002 which is corrupt practices, right? Which is the corrupt practices portion of the Century Code. And what it does is it precludes a person from using property belonging to or leased by the state for a political purpose, okay? That's already in the statute. What it then does, and this is in section 2, is it says that the state, or any agency, department, bureau, board, commission, or political subdivision may not use public funds to be a member, to contribute to, or endorse a private organization that has endorsed a candidate or has publicly supported or opposed a ballot measure. So if you want to summarize that a state, I mean, it's actually pretty concise, but if you have a state or an agency that pays or is a member or contributes to a private organization that has, I'm going to use the word lobbies, or has lobbied for the passage or the opposition to a ballot measure, then this would preclude them from using public funds to be a member of that organization. So it's kind of an extension, my understanding is, of section 1. And then it creates a process in which an individual who alleges there's a violation of those 2 sections to file a complaint with the Ethics Commission. And so it's certainly unique, but that's the substance of it. Does that help, Ron?
Yes.
Any other discussion? Okay, Rebecca, I think we're good with that.
Okay, we will maintain a neutral position on that one. Do we need a vote on that? No. Logan is telling me we don't need to vote on that since we're not, you guys aren't going opposition or support. Is that correct? Okay. Moving on. Dave, am I good to move on to number 4?
Yes, you are.
All right. What was that? Oh, sorry. I thought Logan was trying to get my attention. I will share before I move on to number 4. These are the pieces of legislation that we wanted to talk about today. This is a special meeting, so we wanted to limit it to those. There are a few other pieces of legislation that we will be monitoring that we may update the commission on at future meetings, at next week, at the regular meeting. Number 4, education, outreach, and communications update. So legislative training, we call it legislative training, but it's really providing training for newly elected officials and cabinet members. We did quite a bit of training in the month of December for lobbyists and for legislators and for the public. In January, with the turnover of the new cabinet, what we were hoping to do was, and we had time allotted for, is to provide education to newly elected and newly appointed cabinet members. Well, what ended up happening is we do not have a lot of new cabinet members or cabinet members who are new to state government. They either maintained their cabinet members in the governor's cabinet, or somebody who was in a deputy position or was previously with the office has moved into those roles. I think there's a very, very low number of new cabinet members. And so what we did is we canceled the training sessions that we had set aside for those cabinet members, really because at that point we did not think it was an efficient use of our time. We also had I had a funeral to attend that week, a family funeral, and so it was not really time feasible, if I'm saying that correctly. Instead, what we did is I, along with General Counsel Carpenter, we met with the General Counsel for the governor last week, and really had a good discussion about how best the Ethics Commission can assist both the governor, his team, cabinet members as they start their new terms in handling ethical challenges that are going to come their way. And so what we agreed on was that due to the busyness and all of the work that comes with legislative session, we will wait and have an in-person training that is going to be set after legislative session. But in order to make sure that we have information that got out to cabinet members in an efficient, not wasting time kind of way, during legislative session, the commission staff provided numerous resources to the governor's general counsel that he can then share with those cabinet members and then come back to us with questions. That was our first meeting. Usually our liaison with the governor's office is general counsel. So we again established that protocol for what we do and how we communicate with the governor's office, that is our first call when we need to discuss things with them. And those sorts of good communication protocols we put in place at that meeting. So the other thing is that we provided during organizational session, as I've already talked about with the commission, we did a number of legislative learning sessions with legislators and legislative staff. Currently, the legislature is working through proposed amendments to their internal conflict of interest rules. So after having conversations with legislators, with legislative counsel, commission staff believe that a script that legislators can follow, whether they're in committee or on the House, to declare a potential conflict of interest would be very helpful, would make session run smooth. And we would recommend that we would work with legislative counsel to ensure that the proper parliamentary procedures are followed when it comes to developing a script. But really, this is just to ensure that the process moves quickly. And we are looking just for authorization from the commission to work with legislative counsel. We were hoping to maybe have it ready today, but in all reality, there seems to be some discussion about the conflict of interest rule still. So we will continue to monitor that and then create that script when ready. So with that, I think it would be helpful if we had authorization from the commission to work with legislative counsel and develop that guide for legislators when declaring potential conflicts of interest.
Any other discussion, questions? Hearing none, I'll entertain a motion to authorize commission staff to work with legislative counsel to develop a guide for legislators to follow when declaring potential conflicts of interest.
So moved.
I'll support.
Any additional discussion?
Great idea.
Yes, I agree. That's a very good idea. All right, hearing no additional discussion, Alicia, would you please call the roll?
Dave Anderson,
Aye.
Ron Goodman,
Aye.
Murray Sagsteen,
Aye.
Cynthia Lindquist,
Aye.
Ward Kozer.
Aye.
Motion carried.
Mr. Chairman, I need to step away from the meeting for a few minutes. I'll be back shortly, okay?
Okay. Does anyone else want to take a break? Should we continue on?
How much more do we have, Dave, before we go to executive session?
We have one more item before executive session, Ron.
I suggest we take that and then go to executives, take a break before we go to executive session.
Okay, we'll continue then, and then we'll take a break after that.
Dave, am I good to move on?
Yes, please.
All right, we will hand it over to Logan to talk about the hearing process discussion. I know him and Murray have been working on this.
Yeah, so at the December meeting, we had the discussion about providing additional notice and information of what is expected during the commission's hearing following a complaint investigation. Some of that is outlined in statute and in the commission's rule, but not all of it. Notably, how much time somebody has to present in front of the commission, etc. So we as staff worked with Murray to develop a process to convey this information to respondents. And what resulted from that was a set of 3 documents that work together, as outlined in your meeting memo, but also in the documents themselves. These are attachments 6, 7, and 8. So starting with attachment 6, after finalizing the report and recommendation that the executive director is required to prepare, commission staff would then provide the respondent the first document, which is the Ethics Commission's pre-hearing acknowledgement and stipulation. This is really just a guide of what the commission's process is, that they will be receiving the report and recommendation. They will also be receiving the investigation file, which will serve as the record for the hearing before the commission. Informs them that a written response to the report and recommendation is permitted, but also encouraged. So we get their take on the report, but also what they want to tell the commission. Again, that an in-person response that's also informed to the respondent that is permitted and encouraged, that they show up before the commission at the hearing and provide an in-person oral response to the report. And then we get into more of the nitty-gritty procedural aspects, service of the report and recommendation and the investigation file. But that will be provided to them electronically. We maintain those records electronically, so they will be provided in that form. Unless there's an instance where we have to provide it in written form, we will make sure we work with them, but that we will provide it via email, and then that they can respond via email or mail by sending their response to the commission. And that is directed to commission staff, so then the commission staff provide it to the commission. And then we get into laying out the meeting and the hearing. The legal requirement that it be at a special or regular meeting, which we would follow anyway, but that it's a meeting of the commission, and then we go into the hearing aspect, and we will at least audio record it if the commission meets in person. But if we do these via Teams, we'll also video record it and probably take the audio from it. If they need special facilities, auxiliary aids, or assistance relating to a disability, they need to let us know that so we can make arrangements for them. Then the next piece gets into the time. I'm on the bottom of page 2 here. This is kind of modeled off of an oral argument, like at the Supreme Court, essentially, but how we allocate time in this hearing for the presentations. So the executive director is the one who prepares the report, so we'd allocate them as the executive director 30 minutes to present on what the details of the report and any information that needs to be pointed out. Then the respondent will be given 45 minutes to respond. Then there'll be a rebuttal if necessary by the executive director and commission staff at 15 minutes. These are just guideposts for the respondent to conceptualize what the time allotment is. If more time is needed, that can be done by request and approval of the chair. And that's noted at the bottom of that page. And then if they expect to call witnesses, I'm not sure how often that will happen, but we need to recognize it may and make arrangements if so, but to let the commission and commission staff know before the hearing. Again, telling the respondent the commission will meet in executive session outside the presence of the executive director, commission staff assisting the executive director with the investigation, the respondent, and the respondent's attorney, if they have one, to deliberate on the complaint. So it kind of resembles judges going back to chambers to deliberate on what was presented to them. You as the 5 commissioners would get to do that and decide what you want to do. And then what you will consider the entire record, the report and recommendation, and any response submitted by the respondent. And then the last piece is the finding of the commission and the appeal timeline, providing them some information there that they will be given the commission's determination. It may include a penalty if authorized by law or rule, and then that they have 30 days to appeal it to the district court if they so choose. And after that 30-day timeline, if there's an ethical violation, it becomes an open record. So that's just to certify and have them acknowledge that they've received all this information, that they understand the commission's process going into this hearing. Once they've signed off on that and reviewed that information, we will then provide them the report and recommendation and the investigation file. Then we move on to the second document, attachment 7. This is the meet and confer between executive director, commission staff, the respondent, and the respondent's attorney if they have one. And this is really just to identify a time that will work to have the hearing. How much presentation time they're requesting, if they're requesting more than the standard time outlined in the other document, whether they'll call witnesses or not, and if they'll have any exhibits that need to be prepared or assembled for electronic presentation, etc. This is just to gather all that information, get their contact information, and then sign off on it so it can go to the chair, so the chair can review it, and then find a time that works for the commission to set the hearing on that third document, the draft order setting the hearing. Select the hearing officer. We envision that will probably usually be the chair of the commission, but then the date, time, and location, whether it'll be via Teams or in person, and then setting the presentation time for both the executive director and the respondent, and then addressing any requests for accommodations if there are any. And then the chair will issue that on behalf of the commission. Once all those 3 documents are submitted, the commission can then hold the hearing and make its findings on the report and recommendation and issue a final commission order. So it's really to summarize the process, to make sure everybody's on the same page going into it, to have a clear guide of what is expected of everybody. And so the respondent is aware of it moving into the hearing. Any questions?
That's a lot of information. Well done.
This is Murray. Just a comment. This is I would call this version 1 or generation 1.0. And after the first hearing, there would likely be changes or improvements to it. So I consider this a working document for the commission.
Yeah,
Well
Murray, and
done.
I will add to that. This is with our current complaint process in mind, because we expect there will be reports and recommendations the commission needs to act on before we move into our new proposed enforcement process. So a lot of this will carry over into that, but it might take a little bit of a different form since this is modeled on the current complaint process.
Any other discussion or questions? Okay, then hearing none. The next item then, Rebecca, is executive session to hear the complaints, correct?
Steve, if we could do a motion to authorize the commission staff and the chair to use those documents, just so that we
okay,
have
yep.
that first go around, that we have that.
Yep, I see that now. So I would entertain a motion to authorize commission staff and the chair to use these three documents as discussed for the commission hearing process.
This is Murray. I would make that motion with just a minor amendment or substantively similar. So that you can change a word or two without changing the substance. I move approval.
I'll second.
Any additional discussion? Okay, hearing none. Alicia, please call the roll.
Dave Anderson,
Aye.
Murray Sagsby,
Aye.
Ward Kozer,
Aye.
Cynthia Lindquist,
Aye.
Ron Goodman.
Aye.
Motion carried. Anything else before I would like to take a break before we go into executive session.
Nope.
So what I'd like to do, it's 11:26. Let's take a 10-minute break and then let's all come back into the regular session and then we'll work towards going to executive session. Let's take a 10-minute break, please.
Sounds good. This will be the first one. Post.
Okay, it looks like we're all back. Are you ready to proceed, Rebecca?
Yeah, we're ready in Bismarck.
Okay, the next item on the agenda are complaint numbers 23-014 and 24-040. This item must be discussed in an executive session. The legal authority for closing this portion of the meeting is North Dakota Century Code, Section 54-66-12, Bullet 1, North Dakota Century Code, Section 54-66-12, Section 3, and North Dakota Century Code 44-04-19.2, Section 1. The topic or information regarding the content and parties to a complaint to the Ethics Commission is confidential. As a complaint must be discussed in executive session, no motion is needed to enter executive session. The executive session will be recorded, and all members of the governing body are reminded to limit their discussion during the executive session to the announced topic. Any collective decision, collective commitment, or other final action by the governing body must occur after it reconvenes in an open meeting. The prohibition on taking final action during the executive session does not apply to providing guidance or instructions to our attorney. We will now ask members of the public who are attending the meeting to leave the meeting. We anticipate adjourning the executive session and reconvening the open portion of the meeting at approximately 11:37 now. When do you think?
Let's go with 11:50, Dave. That's the consensus in Bismarck.
Okay. The minutes will show that the executive session began at 11:37 and was attended by Commissioners Ron Goodman, Ward Kozer, Cynthia Lindquist, Murray Sagsveen, and Dave Anderson, along with Executive Director Rebecca Binstock, General Counsel Logan Carpenter, and Operations Administrator Alicia Meyer. Is Patrick going to attend the executive session as well?
Yes.
Okay, then along with our legislative intern, Patrick Fries. With that, then, we will now move to executive session. See you on the other side. Okay, looks like we have everybody. The minutes will show that the executive session was adjourned at 11:59. The public has been invited to return to the meeting, and we are now back in open session.
I
Do I
will
have
make
a
a
motion?
motion. I will make a motion that we direct Executive Director Binstock to summarily dismiss complaint number 24-040 for a lack of subject matter jurisdiction.
I'll second.
All right, Alicia, please call the roll.
Dave Anderson,
Aye.
Ward Kozer,
Aye.
Cynthia Lindquist,
Aye.
Murray Sagsveen,
Aye.
Ron Goodman.
Aye.
Motion carried. Anything else, Rebecca?
Well, we can't talk about anything else because it's a special meeting. So
Right, so I know
we
that,
will-
so anything else related to this meeting that we missed?
Not that I can think of. We will see you guys next Wednesday for the commission's regular meeting. And that's it.
All right, thanks, everybody.
Sounds good. Bye, everybody.
Thank you, Alicia. Alicia, I'm gonna call you. I've got something I may want to add to the agenda for next week.
Okay, sounds good.
All right.
Just